My name is Victor Manibo. I'm a senior attorney here at Wang Law Office, and you are watching the AM Show, Wang Law Office's newest YouTube show.
Hi, my name is Ariel. I'm the host, also a senior paralegal in Wang Law Office. Our show is going to start every Friday at 11 a.m. EST, 8 a.m. PST.
The AM Show is our question and answer show about basic immigration questions. We get these questions from our viewers, from our clients, from prospective clients who send them in through line or through YouTube comments, and we gather them all up and put them all in one episode. For today's episode, we're going to continue our discussion of employment-based non-immigrant visas and immigrant visas, and today we're talking about the L visa.
Victor, before we start today's topic, can you introduce a little bit on your own background?
Sure. Again, my name is Victor Manibo. I'm a senior attorney here at Wang Law Office, and I've been with the firm for 10 years. I've been a lawyer for 12 years, and I graduated from Cardozo School of Law here in New York. On a day-to-day basis, my job consists of immigration litigation, meaning helping defend people from being removed from the country by ICE. I also do immigration applications, meaning helping people gain lawful immigration status through USCIS. And I also do some criminal law work, or crimmigration, meaning the intersection of criminal law and immigration, and helping people protect their immigration status when they have problems with a criminal case.
Yes, and back to today's topic. So can you tell me what is L visa?
So L visa is a non-immigrant visa, and we talked about this before. Non-immigrant means it allows people to come into the United States and live here and do a specific thing for a specific period of time. L is a non-immigrant visa that is made for intercompany transferees. What does that mean? This is for employees of companies who are multinational companies who might have a branch overseas and a branch here in the US. And if they're moving from the foreign office to the United States, this is the type of visa that they can get so that they can come into the United States and keep working for the same company here in the United States. It's also for people who work for a foreign company who wants to set up an office in the United States, meaning the foreign company probably still doesn't have a branch or a location in the US. If they want to send someone to the US so that they can, start a branch office here or a location in the United States, this is also the kind of visa that is good for them.
So this L visa, is there a different type of L visa?
Yes. So there are two main types. One is the L-1A and the L-1B. L-1A is for allows companies to transfer their employees who are managers or executives, meaning these are the people who are in a high position in a company and they do some management of their staff and their operations. They're executives, meaning they implement and they do a lot of high-level tasks for the corporation. And so this is for those kinds of employees, managers, executives that are transferring from one business location into the business location here in the United States. The other one is the L-1B, and this is for employees with specialized knowledge. Now, this doesn't mean that someone needs to be a manager or executive, but they have such knowledge of the business itself, that is very specialized, very specific to the company, that the company cannot operate without them. We'll talk more about what specialized knowledge means, but basically these are like very important, irreplaceable employees that a company might want to transfer from one country into the United States.
So you mentioned the L visa. How long I can stay in the US with this visa?
Generally, it's 3 years and then it's renewable.
Can my family member have L visa too?
Yes. So if you are a beneficiary of the L-1 visa, you can include your family members with you, specifically your spouse and your unmarried children under 21, and they will get an L2 classification. If your spouse is coming with you and they get L2, they can also get an EAD card. They can work in the United States for any employer, not just the employer that hired the L1.
What other benefits are there for L visa?
So the L visa is good because it doesn't have an annual limit. Other non-immigrant visas have a quota. They have a maximum number of applications that they approve. L visa does not have a limit. So, you don't have to worry about that running out of quota every year. Another advantage of L visa is it allows someone to travel in and out of the US as long as that visa is valid. So you don't have to worry about, oh, you're in the United States, you can't leave. You can, especially for these employment-based non-immigrant visas, they do allow you to go in and out. And finally, one good thing about the L visa is it gives you a path into getting a green card, getting lawful permanent resident status for adjustment of status. You don't even have to leave the country. And we can talk more about that later. But that's one really big benefit of the L visa.
So what are the requirements for L-1A?
So we talked about intercompany transferees. It's for employees, right? So because it's for employees, it requires that for this whole process, there has to be an employer and an employee, right? So the employee is the one who is the non-citizen. The employer is the company who's transferring the employee from the foreign office to the United States. Let's think of a big Chinese company, right? For example, they have their headquarters in China, and then they have a branch here in the US. If they want to transfer an employee from China to the US, they will use the L visa. And because of that, there are requirements for the employer, and there are also requirements for the employee, the beneficiary. So let's talk about that one by one. First, for the employer the company has to be doing business in the United States, meaning they have a presence here in the United States. They're a registered business here in the United States, and they have a relationship with a foreign company. Now, what is the relationship with the current foreign company? It means they're part of the same company. They have the same owners, or maybe the company in China is the parent and the company in the US is the subsidiary, meaning it's like a company under another company, right? Or vice versa. Maybe the company in the US is the parent and the company in China is the subsidiary. Or maybe it's a joint venture where it's a 50-50 partnership between these two companies working together. So if you can establish that your employer is in the United States, doing business in the United States, and has a qualified relationship with a foreign company, then that will satisfy the requirements for the employer, for the petitioner.
So you mentioned the word doing business, right? What does doing business mean?
So the company has to be doing business in the United States, meaning they're here in the United States, they have a presence here, they're operating whatever it is that they're doing. Maybe they're selling cars. That means they are buying cars, they're selling it to customers, they have a warehouse, or they have a factory where they make cars, right? Or they're doing business in the future, in the near future. Like I said earlier, the L visa is possible for people who have employment from a foreign company and want to establish an office or a location in the United States. Even though that company is not yet doing business in the United States currently, it will be doing business in the future. So that's what doing business means, meaning you're just going to operate either now or in the future. And obviously, the employer who's doing business has to be ongoing, operating throughout the stay of the beneficiary, right? So it has to be a company that's going to last for at least 3 years. So USCIS is going to look into, okay, what is this employer? What is their business? Is it viable? Is it going to keep going for the next few years? Or if it hasn't been established yet, is it going to be established soon, and will it be operational? Will it make money? Will it have a regular, sales or systematic and continuous provision of goods and services? Those are things that USCIS thinks about. And obviously they're going to think about, is this business going to make money so that it can support itself and it can support the beneficiary by paying that beneficiary salary? So those kinds of things are things that USCIS looks at when they look at the employer for the L visa.
So what are the requirements for the L-1A beneficiary?
So the L-1A beneficiary, now we're talking about the non-citizen, and L-1A is for managers and executives, right? So there are two requirements. First, you have to be entering the United States to perform a job that is executive or managerial in nature. And second, you have to be working for the employer for one continuous year for the last 3 years before you enter the United States. So how does that work? For example, you are an employee of a company in China, and they want to send you to the United States to work in the office here in the United States. You have to be an employee of that Chinese corporation for at least 1 year continuously in the last 3 years before you enter the United States. So that's required. Meaning continuous for 1 year, meaning nonstop. It's not like, 6 months and then you're just working on one project here and there. It has to be continuous. It has to be recent, within the last 3 years.
So you need to be the employee for the Chinese company first, then you come to US, maybe working for the other mother or maybe son company.
Yeah, exactly. Subsidiary.
What does the managerial executive capacity mean?
So managerial or executive capacity, these are very specifically defined terms by our immigration regulations. If you're an executive, that means you manage an essential function of the business at a high level without direct supervision of others. So it's kind of like you're the big boss, Nobody's really supervising you. You can do a lot of high-level tasks, and it's an essential function of the organization. Now, it depends on what kind of business it is to show whether a function is essential or not, if it's important enough for a business. What's important for, let's say, a car manufacturer, for that kind of company, what's important or essential for that is going to be different from a company that says, that maybe creates cell phones, or a company that maybe an international law firm, for example. Different kinds of goods and services for different kinds of companies. They have different requirements of what an executive is. So as long as you can show that you do one of the essential functions at a high level without requiring direct supervision, you are an executive. Now,
You mean the big boss signing for the contract, right?
Yeah, I mean, if you have the power to hire and fire people, that's kind of one of those things. If you kind of run an entire department, you don't have to run the entire company, but if you're running a big part of the company, maybe you're running the marketing department, then you could qualify as an executive. Managerial is kind of similar. Managerial means you have the ability to supervise and control the work of other professional employees. So if you have employees under you that you kind of tell them what to do, you control their scope of employment, you hire people, you fire people, you kind of delegate your tasks to other employees that are subordinate to you, then you are a manager. And you are acting in a managerial capacity. Obviously, that also involves running that whole department or that whole unit. If you're the one who is organizing a department, making sure that the department runs well, or a specific part of the company runs well, you're also a manager. So those are the things that USCIS looks for an L-1A beneficiary. Aside from being an employee of that foreign company for one continuous year, you have to be entering the United States, and that's the job that you're going to do, executive or managerial.
So you also mentioned there's another type, L-1B. So what are the requirements for L-1B?
L-1B is kind of similar to L-1A. You have to show that the employer is doing business in the United States, and that there is a qualifying relationship between the company in the United States and the company overseas, right? And for the beneficiary, you also have to show that you've been working for at least one continuous year for the foreign company in the last 3 years. The only difference is the type of job that the L-1B employee is going to do. You have to show that this person will provide services in a specialized knowledge for that employer. What does specialized knowledge mean? That's something that we can talk about very specifically, but it's not necessarily that you're a manager or you're an executive. It's that you know something about the business that probably nobody else knows.
So can you give me example for the word that you just mentioned?
Yeah, specialized knowledge. It's special knowledge possessed by an individual of the petitioner about their product, their service, their research, their equipment, their techniques, their management, and it has to be an advanced level of knowledge about those things. For example, if you are, let's use the car manufacturer again, right? If you are a car manufacturer, someone with specialized knowledge is someone who knows not just things about cars in general, or how cars work, but they have to know something specific to that company. How does this company make cars? How do they run their operations? How do they design their cars? Where do they get their materials from? How do they sell cars? So the knowledge is not general about the industry, it's not about cars in general or the manufacturing in general. It's about this specific company, that basically if that person wasn't working for the company, a lot of knowledge is lost. So you have to kind of provide that you have to show that you have experience with the company, that you do a lot of very specific things that that other people in the company cannot do.
So is there other special requirements?
Other special requirements are for L-1A or L-2B involve if you're trying to set up a new office in the United States. Again, this is for foreign corporations who have an employee that they want to send to the United States to set up a new office or a new branch. You also have to show, in addition to all the requirements I said, you also have to show that the employer has a physical location for the office. So they've, maybe they've bought property here in the United States, that they registered under a corporation that was formed in the United States. So they registered with the state that they're going to be a corporation, even though the corporation isn't operating yet. And then they purchased property or leased some office space or any location to show that, yes, there will be an office soon. We've started on it. We've bought the place already, right? So that's one special requirement if you're trying to set up an office here. To prove that, you're going to have to show, you have a business plan on what you're going to do once you're going to be in the United States, how you're going to set up the office, what kind of construction or what kind of equipment you're going to put into the new location, and all those kinds of details.
What is the process for applying for Elvisa?
So if you're applying for Elvisa, there are two forms that need to be filed. There is the petition by the employer, and there is a supplement that will describe the beneficiary's background and history. Basically, what is their work experience? What is their relationship with the employer? And what kind of job are they going to do once they get into the United States? Are they working for a location that's already here, or are they setting up a new location that isn't existing yet in the United States? So those two forms, those are the petition and the supplement. And, this is something that those forms can be filed while the employee, the beneficiary, is outside of the country. It also can be filed by someone who is already in the United States. Although that might be a little more rare because there's going to be an unlawful presence issue if you don't maintain lawful status the entire time, right? And also there's the requirement that you are employed by the foreign corporation for 1 year continuously for the last 3 years. And if you're already in the United States, it might be harder to prove that you were continuously employed by the foreign corporation.
So what are the documents required for L-1A and L-1B?
So aside from the forms, there are filing fees because nothing is free with USCIS, and you have to show evidence about the requirements that I talked about, right? So first, evidence about the relationship between the petitioner company that's here in the United States and the foreign company. This could include annual business reports, articles of incorporation, financial statements, those kinds of documents that show that these two companies are related to each other, like a parent subsidiary or affiliates or joint ventures, right? You also have to provide evidence of the proposed job duties of the employee, right? So once the employee is in the United States, what are they going to do? So if it's someone who's a manager or an executive, you have to show internal company documents about what this person has done in the foreign office, because that's going to show what they're going to do, right? Or what experience they have that they're going to bring into the United States. Same with specialized knowledge. What have they been doing in the foreign office? What documents does the company have about the employee's work function? And that's going to show what they're potentially going to do once they're in the United States. You also have to show that, that you've been as the beneficiary, you've been an employee of the foreign company for at least 1 year continuously. So that's going to be, your own financials, maybe some pay stubs, maybe letters from your bosses back in the, head office saying, yeah, he's been an employee here for a really long time, etc. And again, evidence of your experience that could come from, maybe you have resumes, maybe you have internal company documents and memos and reports showing the projects that you've done, the work that you've done, as someone who has managerial experience or someone who has specialized knowledge.
So, any special requirement or document needed for setting up a new office?
If you're a manager, executive, or someone with specialized knowledge who is sent to the United States to set up a new office, you also have to have a few more requirements, because USCIS is going to look at this and say, okay, the company is not here in the United States yet. So we want you to be able to show that this company is going to be existing, right? So like I was saying earlier, you need to show proof that there will be a new business location. Either you bought something, or the company bought something, some property, or leased property for the new location. You have to show that the foreign company is investing in the United States, transferring money to a corporation that is incorporated here in the United States, right? Again, registering that corporation under US laws with a state. You have to show that that corporation is also investing, not just a location, but probably equipment or, assets for that location. If you're trying to build, let's say, a branch office, then you're probably also getting office equipment, right?
Mm-hmm.
So that those kinds of proof. And finally, the corporation has to show that it has the financial ability to pay the person that they're sending here. So financial records from the foreign corporation showing that they have money to pay someone to live and work in the United States while they're setting up the new office.
So what are the documents required for L2 visa?
If you are including your family members, you have to file the L2 forms together with the L1 form, and you have to include the proof of family relationship. That's going to be the marriage certificate for a spouse and the birth certificate for children. Again, they have to be unmarried and under 21, and there is a separate filing fee for them.
So what happens when my L visa is approved?
After it's approved, if you're outside the US, which is usually the more typical route, the USCIS is going to send your file to the consulate or embassy where you live, and you will be scheduled for an interview. You have to show up to the consulate or embassy and answer some questions. It's not going to be that difficult because USCIS already approved it, but the consulate just has to make sure that you're the person and that there's nothing wrong with your application. It should be easy, and then once the consulate or embassy passes you for the interview, then you're going to get your L visa, and then you can travel to the United States.
So after the approval, can I travel in and out of the US?
Yes, like I said earlier, L visa, just like other non-immigrant visas that are business related, it allows the visa holder to travel in and out of the United States because they're probably doing business, right? They're probably traveling between the head office and the branch office in the United States, or vice versa. So they can travel as long as the L visa is valid.
So can I change my employers?
Because the L visa is petitioned by a specific employer, if you come in here with an L visa, you have to be working with that employer for the duration of your visa. You could change your location if it's the same company. If it's, like, let's say, you're working for Walt Disney, right? There's a Disneyland in California. There's a Disney World in Florida. Maybe you work in Florida first, and then they send you to California. That's okay because it's all part of one big company, right? If it's a subsidiary, it's the same thing. If it's an affiliate, it's the same thing, as long as they're all related companies. But if it's a totally unrelated company, you can't do that.
So can I extend my L visa?
Yes, you can extend your L visa. Like I said earlier, if it's L-1A, you can extend it twice for 2 years each. If you are L-1B, you can extend it once for 2 years.
So can I apply for green card after I get the L visa?
Generally, yes. So if you enter on an L visa, as long as you don't have any other issues and you complied with the terms of your L visa, you could be eligible for a green card or lawful permanent resident status if you have a family member who can petition for you. So this is just like the family-based petition that we talked about in previous episodes, right? Or if you don't have family members who can petition for you, you also have the option of doing the EB-1C immigrant visa. This is something that we talked about in the previous episode, right? We talked about EB-1, and there are 3 types of EB-1, EB-1A, EB-1B. We talked about that in the last episode. I said, we'll talk about EB-1C at a future episode because it's more related to the L visa. So EB-1C is related to the L visa because EB-1C is an immigrant visa. It's a green card for people who are intercompany transferees. So think of L visa as the non-immigrant visa, and the counterpart of that for the immigrant visa is the EB-1C. It's kind of like the same process as family-based petition. You have to have your employer basically petitioning for you to get a green card, and you have to apply for the green card itself, which makes it kind of a 2-step process. It's also kind of got the same requirements. The EB-1C has similar requirements as the L visa, but obviously USCIS is stricter with EB-1C because it's permanent, right? It's a green card. So the evidence is going to be higher. They're going to want more, and they're going to look at these closely. We can discuss EB-1C at a future episode, but just know that if you enter on an L visa, eventually you could be eligible for a green card through EB-1C.
Yes, and L visa is a non-immigration visa that allows intercompany employee to live and work in the US, just temporary, but with a path to getting green card in the future. If you think that you might meet any of the requirements we just mentioned earlier, you can call us to schedule an appointment to consult.
Right.
And today the time is up. If you have more questions, feel free to leave your question with us through any of our platform.
Right. We encourage everyone to write in through YouTube or email or line. We know that employment-based green cards or non-immigrant visas can be a little complicated. So if you think you might qualify, please reach out to us. Or if you have more questions, feel free to reach out to us. And now that we're at the end of the show, again, I have to give my weekly reminder. I am a lawyer, and everything that I say here is based on my legal experience, and it's my legal opinion, but it does not constitute legal advice. It's not advice, directly bearing on anyone's case or on your case. It's also not legal representation. If you watch this show, it doesn't mean that we are your lawyer. But if you want legal advice, if you want advice specific to your case, if you want us to represent you as your lawyer, please feel free to reach out to us through any of our platforms.
And you can also continue to follow us on the YouTube. And thank you. See you next time.
Bye.